In the matter before us, the respondent, having pointed to the impugned Section 195 as the legal basis for his misgivings with his trial before the General Court-Martial, the evidential burden shifted to the appellant to factually demonstrate the independence and impartiality of that court. Regrettably, such evidence was not forthcoming. I do not accept the appellant's proposition that military courts in Uganda are impartial and independent simply because Article 221 of the Constitution enjoins the UPDF to observe and respect human rights in the performance of its functions. In my view, that constitutional imperative is simply a directional standard for courts martial rather than a factual situation that pertains to them. Consequently, in complete agreement with the lead judgment, I find that the Constitution of the General Court-Martial does compromise its independence and impartiality as a subordinate court with unlimited jurisdiction, and is to that extent inconsistent with Article 28(1) and 44(c) of the Constitution. In the result, I would resolve ground 2 of this appeal in the negative. On the other hand, under ground 3 of the appeal, the respondent's arraignment before the General Court-Martial is specifically challenged on account of the omission in the charge sheet to indicate his role in aiding and abetting the commission of a service offense as contemplated under Section 117(1)(g) of the UPDF Act. As was earlier observed here, a person that aids or abets another in the commission of an offense is deemed to have taken part in the commission of the offense and, if proved, would be guilty of that offense. In the instant case, an incomplete charge sheet was annexed to the affidavit in support of the petition as Annexure A. It reveals that A1 to A8, with whom the respondent was arraigned, were at the time in active military service and therefore automatically subject to military law. The respondent, on the other hand, is depicted as a civilian, a member of the 10th Parliament of the Republic of Uganda, representing the Kawa Division in Kampala District, and designated as a person subject to military law by virtue of Section 119(1)(g), 117(1)(g) of the UPDF Act. Under count 1 of the charge sheet, the statement of offense is stated as offenses relating to security, contrary to Sections 131F of the UPDF Act, while the particulars of offense indicates that the respondent, together with 22 other named persons and others still at large, between the months of February and June 2016, in diverse places in Wakiso, Kampala, and Luwero districts, with intent to prejudice the security of the defense forces, contrived a plot to overthrow the government of Uganda by force of arms. Close quotes. Although the charge sheet referred to in Section 117, I'll say that again. Although the charge sheet referred to Section 117(1)(g) of the UPDF Act under the description of the respondent, it did not spell out his role in the commission of the alleged service offense. This would indeed amount to a defect. However, not every defect in a charge sheet would make it bad in law and render the ensuing proceedings a nullity. The test to be applied is what the effect of the defect is and whether, if proceedings are concluded, it has occasioned a miscarriage of justice. In this case, no attempt was made to demonstrate any such miscarriage of justice. On the contrary, insofar as the charge sheet highlights the statutory provision that brings the respondent under military law, which is clear on the issue of aiding and abetting the commission of a service offense, the respondent would have been on notice of the nature of offense he was arraigned for. Furthermore, the charge sheet spells out the principal offenders by highlighting their status as persons in active military service. Moreover, borrowing from the civilian courts, under Section 132 of the Magistrates' Courts Act, a court that is faced with a defective charge has a wide discretion to amend it at any stage of a trial. As a similarly subordinate court, that option of amendment of the charge would have been available to the General Court-Martial to clarify the specific role played by the respondent in the alleged offense, as well as demarcate who of the persons he was arraigned with were the principal offenders. Consequently, given the procedural reliefs available to him, I do not find the defects in the charge sheet in this case to constitute sufficient reason to declare the respondent's arraignment before the General Court-Martial a violation of the right to a fair trial. However, Given the then de jure composition of the General Court Martial under Section 195 of the UPDF Act, the respondent's arraignment before that military court cannot have been in accordance with the right to a fair trial before an independent, impartial, and fair court, as envisaged in Article 28(1) of the Constitution. I would accordingly resolve ground 3 of the appeal in the negative. This brings me to what would be appropriate remedies in the circumstances of this case, and whether or not they should apply retroactively. Black's Law Dictionary distinguishes true retroactivity from quasi-retroactivity, the former consisting of the application of a new rule to matters that were completed before the rule came into force, and the latter entailing the restriction of a new legal rule to matters pending completion. In Griffith v. Kentucky, the U.S. Supreme Court reiterated its view in United States v. Johnson on the need to apply a new constitutional rule to all criminal cases pending determination in order to uphold basic norms of constitutional adjudication. That case was cited with approval by the Constitutional Court in Mabea v. Attorney General, and I still consider it to be good law. I would thus equally cite with approval the observation in Duke Mabea v. Attorney General that a new constitutional rule in the realm of criminal procedure be applied quasi-retroactively or restricted to cases pending final disposal to avert the dire effect on the rule of law and the administration of justice of full retroactivity. Griffith v. Kentucky additionally posits that unlike the legislature, it is not the function of the judiciary to formulate laws on a broad basis, its role being limited to the declaration of a new rule directly arising from adjudication. This is similarly acknowledged by the Canadian Supreme Court in the case of Skakta v. Canada. That case was relied upon in Fish Eric in the article Choosing Constitutional Remedies by Fish Erickson. The choice of appropriate remedy between severance and reading in, where a statutory provision violates the Constitution, hinges on whether the nature of the constitutional inconsistency entails something improperly included or excluded from the statute. In the matter before us presently, Section 195 excludes such professional competencies in the membership of the General Court Martial as would mitigate connotations of partiality and non-independence. As such, reading those omissions into that provision might have been the more appropriate remedy, but for the fact that the deference to the competence of persons with a military background was at the time informed by the scarcity of legal professionals in the military, as well as the complexities of securing legal professionals for field courts martials. This is borne out by the parliamentary debate in respect of the then Uganda People's Defence Forces Bill, as reported in the Hansard of that time. So that reading into Section 195 of the UPDF Act, the constitutional safeguards and membership as the court deems appropriate would be tantamount to the usurpation of Parliament's legislative function by judicial overreach. However, the same SACTA case proposes another constitutional remedy that gives the legislature a chance to craft its own solution. Provision for legislative reform therein would, in my view, address the shortfalls of the previous legislative process and provide an opportunity for the review of the military justice law in Uganda, as has been done in other jurisdictions. This would align it with the independence and impartiality safeguards envisaged in the right to a fair trial under the Constitution. It will suffice to observe here that unlike judiciary-driven reforms that ought to be restricted to matters that were in contention between the parties, legislative reform may holistically address matters that were not necessarily in issue before this court. It might similarly accrue to the right to a fair trial in courts martials. This would forestall avoidable litigation in respect of related matters and abide the notion of judicial economy. Disposition. The upshot of my judgment is that this appeal partially succeeds while the cross appeal fails. I do abide declarations 1, 2, 3, and 6, orders 3 and 7, as well as the advisory orders D, E, and H as stated in the lead judgment. In the result, I will set aside the judgment and orders of the Constitutional Court and substitute them with the following declarations. 1. The General Court-Martial is a subordinate court of competent jurisdiction within the confines of Articles 129(1)d and 257(1)d of the Constitution, but its de jure membership under Section 195 of the UPDF Act does undermine its independence and impartiality, and is to that extent inconsistent with the fundamental right to a fair trial enshrined in Article 28(1) and 44(c) of the Constitution. 2. The respondents arraigned before a general court-martial that the jury membership of which does not pass constitutional muster was a violation of his right to a fair trial, and to that extent is inconsistent with Article 28(1) and 44(c) of the Constitution. 3. The provisions of Section 117(1)g of the UPDF Act do delineate exceptional circumstances that would justify the trial of civilians in military courts, and is to that extent consistent with the right to a fair trial as enshrined in Articles 28(1) and 44(c) of the Constitution. 4. Section 117(1)h of the UPDF Act is void for vagueness and therefore inconsistent with the right to a fair trial as enshrined in Article 28(12) of the Constitution. 5. Service offences as defined in Section 1, as well as the provisions of Section 177 of the UPDF Act, are not at cross purposes with either the objective of the UPDF Act under Article 210 or the legislative mandate of Parliament under Articles 79, 129(3) and 210 of the Constitution, nor in any case are they inconsistent with Articles 28(1) and 44(c) of the Constitution. I shall pronounce my final order as the quasi-retrospective application of all cases pending before the General Court-Martial in light with Order 2 above. I would respectfully propose the following additional advisory order for consideration. The General Court-Martial is substantially composed of civilian judges who are directly appointed thereto by the Judicial Service Commission in accordance with the Constitution, as is presently done in respect of judges of the Industrial Court, and the members of the General Court-Martial from within the military should be appointed in consultation with the Judicial Service Commission. I would so order.